So pitfall number one, violating the shareholder eligibility rules. While your LLC was flexible enough that virtually anyone could be a member or part owner, whether that's individuals, corporations, other LLCs, your trust, your S Corp must generally only have U.S. individuals as shareholders. So that's either citizens or resident aliens, with very limited exceptions for certain trusts and organizations. So when people come in and say, hey, I want to set up my business through a holding company, so I want to have another LLC own my LLC interest in this company, you can't do that if you're planning to be taxed as an S Corp. We hear this a lot with small business owners that think that they're going to get more liability protection by owning their interest through a holding company. And we've talked about that in another video. You can check that out. But this is a massive mistake for anybody that's actually planning for S Corp taxation. If a business entity, whether that's a corporation or another LLC, becomes a member, your S Corp election is immediately ineligible. So you need to hold your interest in the company in your individual capacity, and that's going to be true for your business partners as well. The second pitfall I see is when a group of owners comes in and they inadvertently want to create a second class of stock. Now, this is arguably the most complex constraint and directly conflicts with the flexibility that we all have come to love about having LLCs. An S Corp can only have one class of stock. So that means all of the outstanding shares, or what we often call membership interests, or sometimes you'll see called units, have to confer identical rights to both distribution and liquidation proceeds. So what am I talking about here? It's not unusual for an LLC to decide to take on some investors to help grow the business. And oftentimes, the way that we'll attract those investors is we'll offer them something called a preferred return in exchange for their capital. So you might say, hey, put in $50,000 into my business. I am going to pay you 7% on that $50,000 and your share of the profits and losses. So that 7% is the preferential return here. Well, the IRS treats that as a separate class of stock. You've now got one class of stock for the investors and one class of stock amongst you and the other co-founders. That automatically terminates your S Corp election. So these are the kinds of structural things that you have to be thinking about well in advance of having that conversation with your accountant. The biggest one that I see often mess up small business owners that are planning to be taxed as S Corps is issuing what's called a profits interest. So we often see this when you bring on some sort of a key service provider and you say, hey, I can't necessarily afford to pay you yet, or I can't afford to pay you a market salary yet. But what I will offer you is equity in the company in exchange for helping me to grow this business. The idea is that if you help me make this company more valuable, then this interest in the company will be worth more money. You'll be getting a share of the profits. In the long run, it's a win-win for everybody. The problem is that the IRS treats a profits interest as a separate class of stock than what you put in when you actually put your money up. And so by doing that, again, you automatically terminate that S Corp election. So if you're in this situation and you plan to incentivize key people or service providers by providing them some equity in the company while also being taxed as an S corporation, then those people will actually have to buy into the company, or you'll need to come up with a different compensation plan entirely. Now, if you're a startup, this may all be fine. You can have them buy in for little or nothing because technically the company's not worth anything yet. But if you've been at this for a while, you've kind of built up some value in the company, and now you're saying, hey, I got to bring somebody in to help me grow this thing to the next level. They don't want to put any money in, but they're willing to come work for me in exchange for a share of the profits. Well, now you've created this profits interest that's going to negate your S Corp election. Now, there is one sort of loophole or exception when we're talking about this having different interests be treated as different classes of stock. And that's when it comes to voting rights. So voting rights alone are disregarded. So while we can't have the investor with the preferred return, we could say, hey, as an investor, You don't get to vote on these things. Only me and my fellow co-founders get to vote on it. You're going to be a silent investor or silent partner and not have voting rights. That's fine. The IRS will allow that. That won't be treated as a second class of stock. The final one we'll sometimes run into that'll mess up your S Corp election are disproportionate distributions. S Corp must ensure that distributions are strictly proportionate to each member's ownership or membership interest in the company. If you somehow change this up and you start distributing funds in a way that's not based on the ownership percentage, then as far as the IRS is concerned, you've created a second class of stock that triggers the S Corp termination. Where I often see this come into play is when the members aren't making distributions based on ownership percentages, but I see this a lot with family-owned LLCs, where suddenly we're distributing money based on who needs what to pay their bills. Oftentimes in that situation, I see business owners treating their business bank account sort of like a joint piggy bank. And we're just taking out money willy-nilly. We're changing the ownership percentages every time we do the tax returns each year. Things are a complete mess. That's also going to mess up your S Corp election. And the IRS is really picky about this rule, even minor differences in timing, like, oh, so-and-so needed some extra money, so we gave them their distribution on the 1st. The rest of us didn't take our distributions until the 15th. Even that minor nitpicky detail can mess up your S Corp election. These ownership and stock structure rules can be very technical, very complex, and the consequences of messing up the tax status can be incredibly severe. You must review your operating agreements and sometimes, if they're structured this way, your shareholder documents. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If you love what you do and you want to build something amazing, without running afoul of the IRS, then let's talk. Check out the link in the description to schedule a consultation, or if you're not quite ready yet, download our 10-pillar post-formation legal checklist to help you spot this and other issues that could be causing problems in your business.